Hi, everybody. Welcome to Mediation and Beyond YouTube channel. Today, I'm so honored to have with me Veerash Srikison. I'm probably mispronounced that, so I did my best, Veerash. She is all the way from South Africa, and I'm very happy to have her here today. She is founder of Fair Practice Mediation and Negotiation Consultancy. She sent me her bio, which I'm very happy. It's very lengthy, so I'm going to post it in the details of the write-up on the channel. So please go ahead at the end and please take a look and read about her. But I'm for purposes for today, so that we can talk more than I can read, I'm just going to make some snippets about her bio because it's pretty impressive. So Veerash is she's an admitted advocate since 2003 and is currently practices as a civil and commercial mediator. She's founder, as I said, of Fair Practice Mediation and Negotiation Consultancy, an organization that promotes dispute resolution methods that preserve any ongoing relationships while considering the circumstances of each client through her multidisciplinary approach. She uses her expertise in family and child law. She has been invited to address many conferences on the benefits of child-centered family divorce mediation processes. She does commercial mediation. She's mediated workplace disputes to ensure that productivity is not derailed due to co-workers being disgruntled. And that is such a necessity with what's going on in the world, especially during COVID. Her methods of mediation has made inroads in sustaining relationships among co-workers. She also does mediation and negotiation training. She's developed training manuals and toolkits to deliver training to the South African legal fraternity in mediation as an ancillary process to litigation. She's been an ongoing international mediation competition judge. She's been appointed ADR, ODR International Representative for South Africa. She's been awarded Distinction Merit for LLM Mini Dissertation, Mandatory Child Inclusive Mediation. She's been a speaker at the African Child Trauma Conference in Cape Town, South Africa. Let's see, it goes on. I'm telling you, people, she's achieved out-of-court settlements while addressing the concerns of clients who want to walk away with their dignity and integrity to be intact. She's been awarded an overall cum laude merit in ADR by the Arbitration Foundation of South Africa. She is a Harvard-trained mediator and negotiator. And she's a family and divorce mediation expert. She has successfully mediated several family and divorce disputes in the best interests of the children. Her family and divorce mediations are conducted in a family-friendly environment with the assistance of child psychologists and therapists. And where clients are remotely based, Veerash has used online meeting platforms to allow her clients to access her services. And I could go on and on and on, and I will. So I will post that. So Veerash, thank you so much for coming on today. And I appreciate the time that you're giving to talk with me today.
Thank you so much for the invitation, Colleen, and I'm looking forward to our chat today.
Absolutely. So as I would want to know, and I think people who view our conversation today, how did you even get started in mediation just in general?
Well, it started with me being a litigator and realizing that it just wasn't beneficial to the clients. It benefited people who prolonged a dispute more than it benefited the care, the emotional well-being of the clients themselves. I don't think we should take benefit from watching someone suffer or manipulate the situation so that lawyers come out financially more stronger than the clients themselves. So for me, maybe that's my personality. I was not ruthless enough to want to benefit from someone else's pain and suffering. I started to research ways in which dispute resolution can be conducted with the client's interests at the forefront. And that's when I came across mediation. And at that point, it was more of an international practice. It wasn't so, well, it's certainly still not regulated in South Africa, but it was more prominent in the US. And of course, other jurisdictions in other countries were talking about it. That was around 2003, which is when I became admitted as an advocate. And what had happened then was I started to see more of the destruction in relationships when it came to family law in divorces. And one incident I always recall, because it plays so strongly in my memory, is walking up to the court and seeing a family, a mother and children, sitting outside crying. And it was because of not a fair outcome for her in the divorce settlement. And she never got, because she was not represented, she never got to speak properly, represent herself properly in a court of law. And any lay person who comes into that situation doesn't understand procedure, civil procedure. The environment itself is intimidating, so they're just going to keep quiet, and not ask for what it is that they actually need. So researching mediation showed that mediation provides that environment to give to people where they can ask for what they need. And of course, the research then followed, and I just kept, as you saw, kept getting more and more achievements and training in it to fully understand, is this the appropriate process to begin with in terms of dispute resolution? And according to me, it is.
So in South Africa, is mediation used more and more in the divorce process?
In South Africa, our Children's Act mandates that mediation be used when it comes to compiling the parenting plan in terms of the care and contact with children, which in other jurisdictions, they refer to it as custody. But we do have it as referred to as custody in our Divorce Act. However, our Children's Act, which is more recent, refers to it as care and contact with the children. So regardless of the marital status of the parents, all matters related to children must be mediated in terms of the parenting plan or the parental responsibilities and rights agreement. And so when it comes to the separation of parents, again, regardless of their marital status, they are meant to go to mediation to have that document drafted. Mediation, though, is still voluntary. And what we see then is at the tick box approach, where attorneys would send the clients to mediation or use the process in a way that they refer to a person that they know, who we cannot say they're impartial. Some lawyers themselves would conduct it even while representing a client, because they say, I'm a mediator, I'm trained to be a mediator. You know, I'll save you costs if I mediated, and even though I represent a client. So there's all sorts of variations in how this mediation comes about. What we also have is the Mediation in Certain Divorce Matters Act, where our family advocate has the power to mediate these parenting plans or parental agreements. However, they do draw the line in certain instances when it comes to high conflict or where there's domestic violence. And they choose, some of these family advocates choose to not mediate these matters. So it goes into court, where courts perpetuate high conflict. And we do have the structures, the legal structures, the legal framework for mediation. Most recently, we have Rule 41A in our High Court Uniform Rules of Court for High Court matters, and it mandates that all legal representation must consider that their clients do mediation before bringing the matter to trial, bringing the matter to court. So we are making progress, very slow and not popular, but we are making progress towards the mediation process. And hopefully there's going to be uptake, because Rule 41A came into being in March 2020. And so it became used because we were in lockdown and courts were already backlogged.
Right.
So having Rule 41A meant that you could take your disputes offline into mediation, and that's where online mediations became used more frequently. And in using Rule 41A, people could go into mediation. However, and I've started programs on mediation advocacy, knowing and understanding the principles of mediation, the application of the principles, how the process unfolds, there still needs to be more education on that. It's not an alternative to fight. And I think where most legal representatives get it wrong, and I think clients themselves have this belief that mediation is therapy or counseling. Alternatively, they think of it as the mediator making a judgment, because they're sitting there in the middle of this facilitated discussion, and eventually the mediator is going to listen to everything in confidence and then make a decision for the parties. And I think even the attorneys think that as well. So there's a lot of advocacy that needs to happen around mediation process. So we're doing well in terms of promoting the use of it. It's just the buy-in that's very slow.
And do you find that there needs to be more of a buy-in even from attorneys who continue to litigate?
I think so, yes. And I think that the courts, we have recently, and I think in the past 10 years or more, certainly more than 10 years, judgments where the courts have been asking legal representatives, why did this matter not go to mediation? This is after the judgment, and when it comes down to a cost order, why were these issues not brought before mediation? Because they could have been easily resolved. It took 2 or 3 years to get to the court doors, and when it did, it could have easily have been resolved in all that time in mediation. So the judges are being quite strict and stern with attorneys in terms of costs. And we have one very notable judgment, a Brownlee, commonly refer to it here as the Brownlee judgment, that penalizes attorneys for not having introduced mediation to their clients or given their clients a chance to go to mediation to resolve it. So, and we're seeing recently a practice directive that came out of one of our province's courts the judge president sent out a practice directive saying he's not going to entertain matters that where mediation was not considered. So we're starting to see movement there where the courts are taking it seriously. We had a commercial matter that went to court where the matter is called Khalkhadi Manganese, where and that was in July 2021, where the court spoke about the principles of mediation and how effective it was, especially around confidentiality and good faith in mediation. So it's not being ignored anymore. It certainly isn't being ignored anymore.
Well, it sounds like then really you're going to have the movement come from the top down when you really have judges have that buy-in and putting their foot down and saying, kind of, I don't want to say penalizing attorneys, but kind of like shame on you for not taking your clients, giving them the opportunity to mediate, right? So you're pointing a finger and saying, you should have mediated this. Why didn't you? Right. I'm not going to look at this case or whatever that it's going to be, which then kind of leads me into my other question to you. Do you see, which I think you're going to answer yes to this, mediation being used as a kind of a global lifestyle? Because I really seeing it, mediation just being a global lifestyle that we all are going to be on board as united countries, really using mediation to settle disputes.
I do. And what excites me about it becoming a lifestyle is the generation coming up.
Yes.
They have zero tolerance to me for unnecessary conflict. They're very conversational. And like I said, we have a Children's Act in South Africa that recognizes the voice of the child. So already, and they have a right to be represented. They have a right to speak up. It's protected. And of course, what we see on social media, what we see happening on all social media platforms. And, you know, our younger generation, they're talking about climate change, they're talking about children's rights, they're talking about right to education. The lifestyle that's coming up is very different to traditionally what we used to, because they no longer want to be silenced. They want to engage in meaningful dialogue, and that is what mediation is. It's meaningful dialogue where the outcome benefits everyone. They don't want to see that disparity. They're more into equality and equity. They want to see tolerance. They want to see issues addressed. They want to see outcomes in it, not putting things under the carpet, because in the end, they believe it affects them. The outcome affects them, which is what we say in mediation, is the outcome affects you, not me, the mediator, not the judge.
Absolutely.
The outcome belongs to you. And these generations coming up, they have bought into that. They're all about collaboration and community. And you can see the communities building up on social media. So they create those communities which will relate to what's going on in person in schools. And I think that peer mediation programs need to be developed, needs to be promoted, because it is going to be a lifestyle change when, I think, even as parents, we need to tolerate children who speak up, and we have to hear what they have to say. So it is definitely, and I like that you're on the same page as I am. It is going to be a lifestyle change, and it is coming from the top down in my country. So the groundwork now is that more people are outstanding in their comments, and they have fair comments. It's not researched. It's not just something I'm blurting out. They're coming with facts. Mm-hmm. So they know what they're talking about, and it's well versed. So I also want to see that where our generations are coming up, current law students are introduced to the practice of mediation. It's not, and I was talking to a friend of mine yesterday, Valeria from Brazil, where we want to see the curriculum changes in the law degrees, where not 3 years spent on learning how to litigate in terms of civil procedure. However, at least 1 year on becoming a mediator and a negotiator first, and litigation, as ancillary. So not. I think that generation of lawyers that come up now will start to begin to change that lifestyle.
It's interesting because I was having a dinner the other evening with I used to be an educator in an urban middle school many years ago, and we had a peer mediation, but the peer mediation was taught by people who never had a day of mediation in their lives. It was just taught by school counselors and therapists, and therapists are not taught how to mediate. So I'm like, you're teaching children how to peer mediate, but no one's ever been a mediator to teach them how to mediate. And so I said to my friend, I'm like, because there's been an up level here in the States of violence since COVID, especially in our schools. And I think with the year of no children being able to normally be back to school, and the gap, really like a gap year of not being able to socialize. And I think, being home in a violent homes, a lot of these kids and whatnot. But I think we need programs in our schools to help children actually learn how to mediate. I think to solve problems, to understand that that's a real skill set, and to implement that in our school systems, not in college, that needs to be elementary on up. And so, but we need to train people, train teachers even to help them so that they can help students be able to do that. And I agree with you, that is a lifestyle. And I think our youth are really asking for that. I think they really are asking for that, because a lot of them can't get it in their homes, but they could get it in school. You spend a lot of time in school. I think there's a lot of things that we could learn, we could be teaching our youth in schools that they may not necessarily be not be able to get in their homes. Do you know? Yeah. So I think you're making some excellent points about it becoming a lifestyle as I think it can. What would you say is a skill that all mediators all need to have, what would you say that is one skill that you think all mediators need to really bring to the table?
Ooh, I'm not sure if I'm going to see this as a skill or a value, because
Sure, either one, a skill or a value. Yep, yep.
I think for me, it's patience. It's patience
Okay.
with yourself and patience with your clients. Because mediation is hard work.
Yeah.
It's hard work on the part of the mediator, it's hard work on the part of the clients, and it's hard work on the part of their representatives. Everyone needs to be very patient in the process. And it's sort of that go slow to go fast analogy, where we start off with starting to understand each other, understand our languages, understand our behaviors. And mediators must always know that you never, and I'm sure most of them do, is you never walk into the same situation twice. Every single mediation has its unique qualities. So we need to be patient with ourselves in understanding what is happening in front of us. Also take that deep breath and go to the balcony if we need to fully understand how our empathy plays into this situation, in this current situation, and how we have to be very patient with the clients and their legal representatives to bring them to that point of empathy, of empathizing with each other. So it's a long process to get there, and we can't be hard on ourselves as mediators, because most instances we don't see what's going to come. We don't have hindsight to what is going to happen. We just have to be quite trusting in our skills and our competency. So for me, it's patience. Not to say that you must derail the process and take too long with it, is understand that you need to breathe and take your time to bring out the best in yourself.
Yeah, and I think you make a good point. It's not just patience with yourself; it's also patient with the client about where they're at. Right? It's patience with both.
Yeah.
Right. What do you notice in your work over in the part of the world that you're in? Do you notice any gender differences or biases in your work as a mediator, being female?
Yeah, that comes out.
Does it?
I think it's noticeable that I am female. I don't hold my identification to my gender. I am a mediator. It is the people on the other side of it that have that perceived notion that because I am identify as female, that it would affect my impartiality. But as you know, Colleen, we go through intensive training to work on that part of our function, our role as an impartial person. So when I was in the trainings, we talk about multi-impartiality, which means we're impartial both ways. When we go to one client, we're impartial. When we're sitting with the other client, we're impartial. And I think they don't see that, because if there's other females who people identify as female in the dispute, they perceive that you're going to be taking their side. So I spend a lot of time working on any biases they might think I have, any perceived biases they think I may have, to get them to understand our role and what that impartiality means. I do have, because culturally in South Africa, we are a patriarchal society. And so when it comes to the African culture, the leaders and the tribe leaders and the chiefs and the people who do take on the role as mediators in the communities are male. It's predominantly male. The people who negotiate what we call lobola here for marriage ceremonies are predominantly male, because they're the leaders and the chiefs of their, I would loosely say, village or rural areas or communities. So we do have matriarchs as well who are equally strong. It's just because of the patriarchy in our society, the role of mediator should fall to a male. It hasn't impacted me in the sense that I was unable to conduct a mediation because someone felt I would be biased. They do have that initial reservation. it takes convincing, and as mediators, anything can bring in that mistrust. It doesn't even have to be your gender, but I do feel that being a woman, sometimes our competency is questioned.
Yeah.
Because they think we might get emotional because they're used to being around emotional women. And so again, it comes down to our training. We've been trained on how to handle emotion. We never ever say leave emotions out the room, because we know emotions have a huge impact on the negotiation. So they need to understand that you have to trust that I'm, as a female, I know how emotions play in a negotiation and a mediation. So I'm going to be able to manage my emotions, and I'm going to show you, and I'm going to help you manage yours as well.
Yes. Have you ever been, I mean, I know this has happened to me numerous times. Well, you're a woman, so you're going to side with her. I've heard that numerous times. And I don't know. I've never asked a man, but I doubt a man would come in and say, a woman would come in and say to a guy, well, you're a guy, you're going to side with him because he's a guy. But equally, it may have happened, but I get that a lot because I'm a woman. I'll side with the woman. And then try to, I don't explain it away, but try to say to somebody, no, you're in that neutral zone, and I'm not siding with anybody because of anybody's gender, which is kind of what you're sharing, that you're not siding with anybody because of anybody's gender. You're staying in that neutral zone.
Yeah, and I think that our conduct as it progresses, and I say give mediation a chance.
Yep.
And of course, we have our disclaimer. If you see anything that gives you a sign of a perceived bias, please do let us know so we can understand what you're doing. Yeah,
absolutely. But there is that hesitancy based on gender, and I think that's at least people are bringing it to the table and speaking it, which I'm grateful for, rather than just say, well, I'm not doing it. So I think that's it. I do think even though it exists, it's a step in the right direction.
And I like that because they're being honest, they're being honest, and that's a good step. That's right.
It is a good step. I don't have to like to hear it, but I'd rather it, at least we're speaking it, right? One of the last things I mean, I could talk to you all day, but one of the last things I'd like to ask you is, what would you like your contribution to have been for your time here on the earth? What would you have like your contribution to have been for your time here? Whatever that time is, right?
Yeah, we're all on borrowed time right now.
Yeah.
I think watching what was happening in the last 18 months or so, I think that's people's purpose has changed. I think they're focused more on what's the legacy I'm leaving behind. Mm-hmm. And for me, I am a parent. And of course, when I started out with mediation all those years ago, one of the turning point for me was becoming a parent. And what is the world that my child is going to live in? What is the world other people's children are going to be living in? So in addition to taking on a more peaceful process of dispute resolution in terms of the way I practice and maintaining those relationships and endorsing amicable relationships, because if you have children, if that relationship never ends, I'm training mediation and negotiation to people, because mm-hmm. If I were not to exist tomorrow, what did I leave you with? Right. I need to leave you with skills. I need you to leave you with coping mechanisms of communication, where you are able to not just ask for what you want, but ask for what you need, at the same time recognizing what someone else needs. And that sometimes you may not need the same thing, but you're able to gain value from each other. And for me, what I want to leave behind are those teachings and trainings that people learn, because I'm constantly learning. I've never stopped learning. I never will. Mm-hmm. And for my child to know that this exists. My mom left us behind. And so even if you were to pick up my training manual, he'll go, my mom taught that to hundreds of people. She was probably doing something right if hundreds of people came to
Yes. Yes.
And so if he, you know, that's the legacy. And if he can see the goodness in communicating effectively, then I've done my bit.
I think that's perfect. And I think that's a perfect note to end a beautiful conversation on. So thank you so much. I wish we had more time, but I'd like to have an opportunity in the future to have you back on again, because I really have enjoyed our dialogue. And thank you for this morning with our technology efforts. Talk about patience. We were both very patient in trying to make that happen today. So I appreciate it. And I really appreciate getting to know you. You obviously are a wealth of information and just an easy person to really get your message across. And I really hope people take the time to read about you, look you up, and I will have how to get in touch with you in the notes below. And thank you so much for your time, Veerash. I really appreciate it.
Thank you so much, Colleen. Thank you so much for your time, your patience, and this opportunity. I had so much fun. Thank you so much.
Absolutely. We will be back in touch, and look for Veerash at Fair Practice, and look for her notes below. And thank you, everybody. And we'll be in touch soon, Veerash. Take care.
Thank you. Take care.
Bye-bye.
You too. Bye.